Good afternoon to everybody. Can you hear me?
Yes, good afternoon.
Yes.
Okay, that's great.
Yes.
Sorry, just to verify that it's okay. Now, where were we last week? We were just finishing. I didn't manage to finish the slides on jurisdiction. I just want to finish because this is something interesting that maybe seems obvious to our British students. I see Kid is online. I don't know if also Wood is online. I'll just to point out that I think it's very interesting for non-British students to see how legal systems can work in a rather different way. Now, let's go. Here we are. Now, as I've mentioned, sort of in all the Western world, lawyers go to a law school, take a law degree, and then many go in the legal profession, others do other kinds of activities in continental Europe. They can do practically anything. They can go in public administration, in enterprises. They can be painters or musicians. I mean, it's a degree that opens lots and lots of doors, not only those of the legal profession. In the US, it's mostly focused on the legal profession. But we have one noticeable exception, which I want to mention to you, not only because to our Italian students, not so much because it's strange, but it should give you food for thought. In England, until the mid of the 20th century, that is just until the sort of after World War II, the majority of barristers, that is the practicing lawyers that went in front of the court, not the solicitors who were and still are mostly engaged in non-judicial activity. They are engaged in some, but not in all of them. Well, barristers that substantially made the English law because they were members of the bar, and then from the best barristers, came the judges of the English judges. First element, the majority of barristers had never gone to university, or if they had gone to university, they had not necessarily taken a law degree. Now, this seems very, very strange to us, whether we are in Europe or in the US or in Latin America, find that there are lawyers who do not have a law degree. Now, things are different now, but we must see this in a historical perspective. So in the perspective of how the law develops and the law courts develop in England from the 11th century, from the 12th century onwards. Now, what is interesting to notice that it isn't they weren't universities. They were Oxford and Cambridge, which were founded after Bologna, obviously, but they were founded pretty early and were of a great repute even at those times. And they all had law faculties, both Oxford and Cambridge, and the English universities that came after Oxford and Cambridge, and they had law faculties, but lawyers did not go to a law faculty. Now, how is this? Why is this reason? Why is it that in Italy, France, Germany, not just in Spain, just to give you the idea of the main places where sort of the legal system developed in the sort of starting from the 11th century. Why did lawyers go to university in Italy, starting from Bologna, and then all the other countries that imitated the Bologna model? While in the UK, in in UK, in England, lawyers, practicing lawyers, did not go anywhere near a law faculty. Now, this has very much to do with medieval organization of society and especially of professions and trade. Now, if I'll try to bring our Italian students back to the sort of basic ideas, basic notions they studied when they studied the Middle Ages, and think of medieval Florence. In medieval Florence, well, you had a whole lot of guilds. Let's write this down for our Italian students. Let's see if I can now okay, let's chat. Okay. So we just think of medieval Florence, and where you had a whole lot of guilds. What are guilds? They are professional organizations in which all those who are doing a certain activity join together. And you had goldsmiths, silversmiths, and obviously those who were dyeing fabrics, and those who were obviously tailors and plumbers and so on. So each profession had its guild. Now you transfer this from sort of these trade activities and trade and small arts and crafts activities, transfer this to the legal profession. So what happened in England, the courts were all concentrated in London, and when there was some bright youngster, bright or less bright youngster, who decided he wanted to make a profession in the law and become a lawyer and become therefore a barrister. He went to barrister and started working there as an apprentice. And after years and years and years after apprenticeship, finally he was admitted to the bar. So this is the whole idea, is that the tradition was that you didn't go to university, you went immediately and you started to practice the law at a very menial level, doing for example, copying. Just think of those times when obviously there was no print, there was no typewriters or computers, and so you had to write. Everything had to be written by hand with quills and with ink on parchments, and so they did very sort of menial activities, and if they showed they were apt to do this kind of activity, they learned their business, then very slowly they advanced in their apprenticeship, and finally they were admitted to the bar. And so the tradition was that you didn't go to university because you had no time to lose in studying the great system of the law and studying the law as at a university. Law, it was a practical profession, and you had to know precedents of the courts, you had to know obviously the judges and so on. So there was no need. What is the need of theory? Now, this approach, which is a very practical approach, has not prevented English law from developing in a very sumptuous way, a very rich way, only with certain elements of striking elements. And this is why it's important we we mention this experience, this historical experience. The fact that the legal system does not necessarily require a theoretical background. Theoretical background may come much later. we in the European continent, whether we are in Italy, Spain, France, Belgium, Germany, we feel that we need a system. We must build a system and we must put everything in order in the system, and then we can put the system into practice. In England, for at least more or less 8 centuries, well, they felt that the system, there was no need of a system. It was case by case. And so you had to know all the precedents, you had to know which were the good precedents, which were not useful precedents, and how to change the arguments, how somehow push the learned judge in your favor, but you didn't need a system. This is why, if we look at the history of English law, for us continental lawyers, we find it very disorderly. Why? Because it doesn't come from a system. Nobody built this system. There were cases, if some certain cases came to court, well, there was a precedent on that issue, but if there were no cases brought to court, for example, because nobody quarreled about that point, well, there was no decision, and it was taken for granted that the parties could agree however they wanted. Now, why is this very important? Not only gives us an idea of how the English system developed, and it developed in a very different way from how it developed in continental Europe and in the US, because the US follows the continental European system, at least from the point of view of a lawyer since the sort of the 18th century. You were a lawyer, and if you had gone to a law school, if we look at many of the founding fathers, they had gone to a law school. So I mean, they were lawyers. So to become a practicing lawyer, you had to go to a university, Harvard University, one of the first in the US. So just to point out that it gives us an idea of how the system developed, and I said until the sort of mid of the 20th century. Then what happens? Well, solicitors who are, let me write this down for our non-British students. Who are, well, practicing lawyers, but who originally could not go to court. Now they go to court in many matters, but not on very big matters. Big matters are always in the hands of barristers. But solicitors, well, they started the requirement, the Law Society, that is the professional organization of solicitors, said, well, to become a solicitor, you need a law degree. And gradually also, this was a requirement, a degree was a requirement for barristers, but not necessarily a requirement, a law degree, because if we look at see if I can change my page. Yes, if we look, first of all, this is interesting from a historical point of view. There's this great English jurist, William Blackstone, who is somehow the one who started putting English law into a system. And you see this happens only at the mid of the 18th century. So William Blackstone, who's fundamental if one wants to learn, his commentaries are fundamental if one wants to know the sort of structure of English law. Well, he was the first barrister to become a professor of law at Oxford. I mean, if you look at the history of great lawyers in Italian history of law, or whether it is German or French, I mean, it's always the same. These histories are parallel. But if we look at the founders of the Bologna law faculty in the 11th century, they were practicing lawyers. They were doing both. They were law professors, but at the same time they were practicing lawyers. So what we see is that only in the 18th century there is a practicing barrister who is called in Oxford and teaches and teaches law in Oxford. But he thinks this is, no, he's not gratified. I mean, in continental Europe, lawyers would kill each other to become professors, and they would feel that this is their most important achievement. William Blackstone, he teaches for about 10 years and says, oh no, but I'm fed up with teaching. I much prefer being a judge. And he returns to London to be a judge, but not sort of a House of Lords, Court of Appeal. No, just a first instance judge. He feels it much more gratifying. So this gives you the idea, the frame of mind in which English law developed. Now, just to point out that this is not only something of the past. You say, oh, but this goes in the museum. If we look, I've just made a list of very important law lords that were sitting in the commission, in the Judicial Committee of the House of Lords, and then afterwards in the UK Supreme Court. Now look at Lord Neuberger, President of the Supreme Court of the United Kingdom from 2012 to 2017, and he graduated in chemistry. Now in continental Europe, or even the US, nobody graduating in chemistry would become president or of the highest court of the land. As a matter of fact, Lord Neuberger comes from sort of family full of those, I don't remember whose, I think it's Wood. Maybe also Kidd is in Warwick. Anyhow, one of his brothers is teaching or was teaching some scientific matter in Warwick University. So just to point out, graduate in chemistry. Lord Sumption, graduate in history at Oxford. Very noticeable historian of the Crusades, sort of written very important books on the Crusades. Member of the UK Supreme Court. Lord Bingham, someone who has substantially brought human rights into English law. Well, he was graduate in history again. Lord Lowry in classics. Lord Mackay, mathematics. Lord Scammon in classics. Lord Diplock in chemistry. And if you see, it's not so long ago. So just to point out, this is a tradition by which to become a practicing lawyer and then a judge, you don't necessarily have to be graduate in law. And if you read the opinions of these law lords, well, they are really very, very. One reads them with admiration. One thinks, one looks at them and sees, look at all the legal thought that is in there. And that tells us that to become a good lawyer, not necessarily you have to study a system. Well, obviously you must be bright, you must be intelligent, you must be thoughtful, but not necessarily you need to pass through all the the studies which typically have forged in continental Europe for centuries lawyers. Now, this is not to say to our Italian students that they shouldn't study law, because this is our tradition. I mean, but if they were born in England, well, clearly they could have taken something different, a different road, academic road, studying something different, and maybe at a certain point deciding that the law is could be their profession. So just to point out, this is very important to show us when we look at sort of building blocks of a legal system. Well, a university is not a building block of the English legal system, and I will come to this notion of building blocks in the conclusions of the course. I will try to show you, sort of give you some ideas of what are building blocks of a legal system and how we build a legal system. So this is just to point out that the English exception is very useful for us who do not belong to that tradition to understand how a legal system can work perfectly well, because in England it isn't that nobody was saying, oh, but we need a legal system. The law is in a lamentable state because our lawyers our practicing lawyers and our judges have not gone to a law faculty. Nobody complained about them and were being very happy with their judges, and so obviously the system works. So it means that it obviously means that change in the history and how the history develops. So certain things that seem obvious to us in continental Europe, I tell you, from Germany to Cyprus and from Portugal to Poland, seems quite obvious to us. Well, it is not obvious in England. Now, having said this, and now, and having therefore closed our, let me go here, stop share for a moment. Well, what are we going to do now is, if there are no further questions from the class on this, to us, for us, continental European, rather bizarre model, but I repeat, it seems very strange to us, and then we realize it works. You look at it and you see it works perfectly well. What I would like to do now is bring you in a different dimension, which is the international dimension. So we have looked at legal systems, and we have looked at the legal systems mostly from inside, how they're structured inside. Inside, obviously, the borders of a certain, of a country. And, but this is only one aspect of a legal system. And particularly in these times, well, sorry. We realize that sort of the international dimension of legal systems is particularly important. And so what we should try to do in this week is trying to understand how our legal system is influenced and influences international relations, and if we can talk of a sort of a world legal order, or if we can somehow, and what are the sort of the legal aspects of what is called, quote unquote, globalization. We shall see this. Yes, here we have Di Domenico Antonio. Go ahead. You want to write the question, or you want to?
No. I will ask you. Can you please repeat again the main role of the solicitors, their main distinction also with the?
Now, okay. Now let's put it like this. Now, can I ask? Kid, can you answer the question between what is the difference between a solicitor and a barrister? Kid, are you there?
Yes, hello.
Can you answer Domenico Antonio? I mean, you are the sort of the, let's hear it from the horse's mouth. You are there. I don't know if you want to become a solicitor, barrister, or what? But can you explain to Domenico Antonio what is the difference between a solicitor and a barrister?
Yes, I can try. So a barrister is sort of the advocate, the one that will stand up in court and present the case in general, whereas the solicitor is sort of, in criminal cases, would be the one that prepares the case, collects evidence from witnesses, speaks to the person. So the barrister is more the advocate rather than the solicitor.
Now, let's put it like this.
Thank you.
What happens? Solicitors, well, they were in the backstage for centuries. At a certain point, well, the English economy sort of starts booming. Industrial Revolution, 18th century, and England goes, well, becomes sort of a world power, colonial power, and, well, obviously business is thriving in England and Great Britain. Now, obviously, to make these activities, to make all these business activities, And to set up those companies, we've seen that companies started being created in England in the year 1600. Well, obviously you need lawyers. You need someone who writes contracts, someone who writes agreements, company bylaws, and so on. So you need a whole lot of activity, which is non-judicial. It is, if you have to draft a contract, well, obviously you must protect the interest of your clients, and you hope you never go to court. Now, this kind of activity was not considered by barristers. Barristers did not do that. Barristers were only there to go in front of the court. This is what they had learned to do for centuries. They were litigators. They went in front of the civil courts, of the criminal courts, of the other kinds of tax courts, maritime courts, commercial courts. They went in front of the court. They were barristers because they could go beyond the bar that separated the court from the public. So only they could speak to the judge. Now, to make these activities, these very important legal activities, I'm just mentioning mentioning contracts, but you could think of wills, you could think of family deeds, you could think of a whole lot of legal activity, which hopefully does not get to court. Well, you needed lawyers. So solicitors who were at the for centuries, they'd been, in the backstage, in the back office, doing a rather obscure work, started coming out and started growing of importance. And they grew of importance, grew and grew and grew, because they decided, hey, we're going to join together. We're going to do some kind of partnership. We're going to become a law firm. Traditionally, barristers did not have a law firm. They had chambers. If you go to the Lincoln's Inn in London, you can see still these chambers. And their chambers, they had a room inside a building, and there was someone looking after this building, but each one was by himself. While here, solicitors start doing a law firm. These law firms, they start, well, very early, in the 18th century, and then growing the 19th century and the 20th century, and become economic empires. And what do? They do business activity, whether it is mergers and acquisitions, whether it is drafting agreements for company shareholder agreements, whatever, any kind of legal activity. And they grow and grow and grow and become very, very important. And if you look at the many of the main law firms, which the Linklaters, Freshfields, just to mention a couple, and a whole lot of other big international law firms, these are made by solicitors whose main activity, not exclusively, main activity is non-judicial activity. Then there may be a case in court, and they will go to a barrister. Although now in certain matters, typically family matters, there's a divorce, and you have to go in front of the judge, or there are small claims, judicial claims which are not so important. Well, the solicitor can do that. But when they're very big, important cases, one always goes to a barrister, because the barrister knows the judge. Because the judge was a barrister years ago, and so one supposes that the barrister knows how the judge thinks and all his precedents and what is his frame of mind. But the solicitor is the let's put it in a very simplistic way, it's a business lawyer. He's a business lawyer and does business and assists businessmen, companies, and so on. So this is the great this distinction. Now, this distinction, as I've mentioned, is less so obvious as it was, let's say, 50 years ago. But this is how if you look at the English, at the legal profession, you still have these huge, very big law firms, and which make millions and millions of pounds per year, and well, barristers whose role is that of going in front of the court. And that is that they only do that, and they only have, while solicitors occasionally go in front of the court, barristers will only do that and will not start doing business transactions. That is not their activities, and they're only to go in front of the court. So I hope this has made this clear to
yes, perfect.
Adimari.
Thank you, Professor.
Yes, Adimari.
Isn't a solicitor a kind of notaio?
No. It's nothing to do with a notary. Let's say, first of all, notary is there are very various notions of notary. If you go in the US, notary is anybody who's in a tobacconist, and he will know. Solicitor is a business lawyer. He drafts contracts, company agreements, wills, mostly in any kind of business activity that needs a lawyer behind this activity. So it has nothing to do with the notary. Solicitor can, every now and then, in certain cases, he can witness certain will, for example. He or she can witness the will, and therefore the will is valid because it is signed by a solicitor. But generally, when we talk about solicitors, we mean traditionally from, let's see, from the 18th century onwards, business lawyers who draft contracts and are engaged in all kinds of company activities. Is that all right?
Okay, thank you.
Okay, now let's move. So I was mentioning, let's move and look at the relationship. So I just would like you to see, when we're looking at comparative legal systems, it's not only looking sort of England and Germany, US and Italy. No, what I would like you to keep in mind that legal systems do not live by themselves, and they live in a world, and this world is full of international relations. You can be close as much as you want. Even sort of, let's take the most close country which one can imagine, North Korea. Well, North Korea has relations with the People's Republic of China, at least, and the president of North Korea then has to meets the president of the US. We're not quite sure what came out of these meetings, but anyhow, even a country that says I'm going to live by myself has to have relations with other countries. So obviously we're going to look at Western legal tradition. So we're looking at the Western sphere, that is Europe and North America and South America, and obviously Australia and New Zealand. So we're looking at the Western legal tradition. So we look at this, and then then at the end of the course, I'll try to move out of the Western legal tradition, but just to point out how different the notion of law is in other legal systems. Now, sorry. Okay, can you see the slides?
Yes.
Okay, now, international law. Now, as this is for our Italian students who are first year students and obviously are not familiar with this, maybe our non-Italian students are not familiar with certain terms. What do we mean by international law? Well, international law is a very big sort of container. It's a label under which we find many legal aspects. I will just focus on four of them. When you will study international law, as you will have to study international law, well, you will see that it is much more complex than what I'm trying to present to you in a very simplified way. But this is just to give you an introduction, to make you, so you know that there's, well, there's not only, we don't have to look only at the law inside our country, our own country, whether it is Italy, Belgium, or the United Kingdom, but we have to, well, we have to look at also some, other aspects. So, first of all, what are these aspects? I'll mention these four. Rules and principles governing the relations and dealings of nations with each other. Now, clearly, countries may decide to just, let's go way back in history, sort of Athens and Sparta do a treaty in order to defend each other, but to defend themselves from the Persians. So, well, that is an international treaty for those times, and obviously a defensive treaty in which they decided that they should somehow give assistance one to another. So there's always been international relations, and these international relations have had a legal form. If you look at these international treaties, and we find these international treaties, well, way back in the history, sort of 4,000 years ago, well, there's a preamble which says a whole lot of very important things which have to do mostly with the gods or with other sort of supernatural aspects, but then the content of these treaties are legal. So the law that governs the relationship between one country and another country, well, that is the main aspect of international law. So they're not sort of only sort of two heads of state meet, shake their hands, do a photo opportunity. It goes on the social media and so on. No, it's, well, there's a whole lot of negotiation, and then at the end there's some kind of legal agreement which is binding for the two countries. So this is first thing. So rules and principles governing the relations and dealings of nations with each other. And obviously they may be much broader, multi-nation, multilateral agreements and sort of international agreements which put together many nations, but the basic is two countries that decide that they want to agree on certain aspects, and that is binding for those countries. Then the second aspect, international and supranational organizations, which I won't make sort of a long story about this, but if we look at how the system is after World War II, well, obviously we find the United Nations organization, then all the umbrella organizations under the United Nations, whether it's the World Bank or the World Health Organization, International Labor Organization, and so that is all the international organizations that are under the big umbrella of the United Nations. Then we find regional international organizations, the European Union, the Organization of African States, and or Organization of American States. So we find regional in the sense that they're not world, they concern mostly one continent or part of one continent. And so we find international and supranational organizations, which is another very important aspect of international law, because many countries join together and create a common organization. Then the issue of relations between states and individuals of a different state. So that is the first element. So one state has relations with individuals who are in different states, or vice versa, or again, relationships between individuals of different states. Just think of an Italian man marries a Japanese woman, or vice versa. So, problems of how you regulate the marriage between these two people of different nationality, Japanese law, Italian law, what? Or a contract between a sort of a Chinese company and a Spanish company. What is it? How is it regulated? And last aspect I would like to point out, activities of private entities in the international arena. So what happens when private entities, and we're mostly talking about companies, very big companies, what happens when they operate not within the boundaries of a country, but when sort of the kind of relationships they have are sort of cover many countries, and therefore one has to try to understand how they are regulated. So these are just to point out 4 aspects which I would like to sort of focus on in this module in this week. And so these are some of the points we shall consider. Now, the first, I'm focusing on the first point. So the rules and principles governing the relations and dealings of nations with each other. So we have 2 countries. So let's imagine Italy and Canada, or South Africa and Brazil. Just think of 2 countries. So here we have 2 different approaches. Now these are technical approaches which you will study when you study international law. You have 2 different approaches. The relationship that there is between international law and domestic law. Because what I would like to point out that when we look at international law, we mustn't see this international law as it was some kind of field of law which is somehow placed on Mars, on the moon, distant, and has no relationship. Say, oh, but that's international law. No, we shall see that international law is very important for domestic law and influences domestic law, although they may be different levels, different degrees of influence of international law on domestic law. So we must not, as lawyers, and as I'm telling this to our first year students, sorry, just trying to get this mouse, get it reasonably. And to our first year students. So don't just think that, well, that's international law. No. International law is very important. Then we should look, as lawyers, we should try to understand what extent that international law is valid, has effects, but it is part of our legal system. So we have 2 approaches, and these are 2 theoretical approaches, which are quite clear and are very well developed throughout the centuries in the Western world. And we find, variously, we find them here and there. We sort of, you can't do, well, these countries follow this approach and these other countries follow another approach. We have these 2 approaches, the monistic approach and the dualistic approach. What is the monistic approach? The monistic approach is, monistic means obviously whole, we could put it. It gives the idea that it is monos, one, only one. When a state, when a nation agrees, signs an international treaty, and it is approved as a seal of the state, well, that treaty becomes part of the domestic legal system. So this is the monistic approach, saying, well, international law is simply one part of domestic law. We will look at, it has to do with the relationships of the state with other states, but it is part of our domestic legal system. While in the dualistic approach, that means it gives the idea of 2. One is altogether monistic and dualistic. 2, he says, well, in order that for international law to become part of domestic law, there is what is necessary, a specific act, which is generally an act of parliament. So if we want this, this law, this treaty, sorry, to become part of the domestic law and therefore to create obligations not only for the state, but also inside the domestic legal order, well, Parliament must intervene. We generally say Parliament, Congress should intervene and specifically say that that international treaty is valid in the domestic order. So you see that there are two approaches. Now, just keep in mind this, but you will study this more appropriately deeply when you study international law. Keep in mind that, well, the distinctions are not very clear-cut. Most systems are middle way. For certain aspects, they're monistic. For other aspects, they're dualistic. It depends very much on what is the content of the international treaty. Because clearly, if you're doing an international treaty on on extra space exploration, well, that probably has to do only with the states. But if you have something that has to do with other aspects, just think of protection of endangered species, and you want to avoid that there furs of tigers and of leopards and of lions, or elephant tusks that are brought into a certain country because you don't want these endangered species to be extinct in certain countries simply because in another country you want very much elephant tusks, or people want to go around with leopards or with a tiger skin, a fur coat. You realize that this is an agreement, an international agreement, well, that must have some effect inside. So it depends very much on the content. So we don't really find countries which are only exclusively dualistic and countries that are only exclusively monistic. You find often to different degrees, some that are more monistic and some that are more dualistic. Now, this is very important from when we look at comparative legal systems, because we are very interested in trying to understand to what extent international law influences a domestic legal system. So the difference is we are trying to make a difference between systems that are more open to international agreements, which therefore influence significantly the domestic law, in orders that are more legal systems that are more closed, and therefore that filter the international agreements and let inside the domestic system only a few or not many of them. Now, let's just to show. So, what is the main difference? And this, you see, where shows that this is not only a theoretical issue, the distinction between monistic approach and dualistic approach. Well, in the monistic approach, international treaties, once they are signed and they have been approved by the government and have been duly signed, create rights and obligations inside the domestic legal order that can be enforced by the courts in favor or against its citizens and entities. So just think of an international treaty that forbids the trade of elephant tusks, and someone is caught in Italy with doing some kind of work with an elephant tusk. Well, they will be sanctioned for that person. Therefore, and this will have consequences, significant consequences against the citizens. Or just think of an international treaty on the protection of cultural heritage. And just think of someone who's someone in Italy who had a Renaissance painting who's been stolen and then has been brought abroad, smuggled abroad, and sold in, let's say, in the US or in Japan, and suddenly the owner of this Renaissance painting sees that this painting is being sold at an auction in the US or in Tokyo, and well, has rights and says, hey, listen, there's an international treaty against the smuggling of cultural heritage. This painting is part of the cultural heritage. I want it returned here. So just to point out that this shows that the monistic approach somehow, when the country follows by and large the monistic approach, this means that the courts can apply directly these international agreements because they feel they create rights and obligations which are enforceable within the domestic legal system. So this shows you a very practical aspect of the monistic approach. In the dualistic approach, well, what happens is that international treaties create rights and obligations only for the signatory states. So it is only the state that has an obligation, not its citizens. It is the state that has obligations, has rights and obligations, not the citizens. And therefore, if another state challenges and says, you haven't abided by this international treaty, well, there will be some international jurisdiction, the International Court of Justice, which sits in Hague, the International Tribunal for Law of the Sea, which sits in Hamburg, and we have a whole lot of other international jurisdictions, well, in which the parties of the litigation are only states. So only the states can be brought in front of that jurisdiction. They can, but that treaty is not enforceable within the domestic legal system. Just to make an example, as we have our British students with us, until 1998, which is when the Human Rights Act was enacted in the United Kingdom. What is the Human Rights Act? It is substantially the transposition in English law of the European Convention of Human Rights. Until the year 2000, because the Human Rights Act entered into force in the year 2000. Until that time, the European Convention of Human Rights was binding for the UK, which had signed this international treaty, but was not enforceable in front of the British courts. So if someone went in front of the British court saying, oh, but my rights, which I established in the European Convention of Human Rights, have been violated, the English judge would have said, sorry very much, well, I can't do anything about this, because this is an obligation which is binding only for the United Kingdom. It doesn't bind me, I cannot enforce this. So if you want to complain, if you're a British citizen, you want to complain, well, you have to go to the Strasbourg court, and which has jurisdiction for this. And so for at least 40 years, British citizens were going in front of the European Court of Human Rights saying, listen, my rights which are established in the European Convention of Human Rights have been violated by the UK. And the European Court of Human Rights said, well, yes or no, and said, well, the UK has violated this convention, has violated its international obligations. So, and therefore it is the country that has violated its international obligations. But that convention did not create any domestic right for British citizens or domestic duty for British authorities within the British legal system. There was an international obligation, and it could be enforced only outside in front of the international jurisdiction, which is the European Court of Human Rights in Strasbourg. From the year 2000 onwards, this is no longer the case because substantially that European Convention has been transposed in the Human Rights Act of 1998, and if you compare the two texts, they're substantially the same. And so this means that those rights which are enshrined in the European Convention of Human Rights are perfectly well applicable in front of the English courts. Lord Bingham, which I mentioned before as one of the most eminent English judges, well, he was substantially the judge that somehow brought inside English case law the whole Human Rights Act. And when he became, as soon as the Human Rights Act became law, he started applying it in many, many decisions. You find dozens and dozens of his decisions in which he applies to English law and substantially changes English law through the Human Rights Act. But until that date, until the year 2000, following the dualistic approach, that convention could not be enforced in front of the British courts. And we find other cases in which the parties of the agreement say this treaty is valid only for the states, obliges only the states, does not create any rights or duties for the citizens of that state. So it depends very much on what is the topic, what is the argument of the international treaty, and what the parties agree. So, returning to the starting point, well, and to compare legal systems, we are interested in understanding to what extent legal systems are very open, and therefore they are very much influenced by international agreements because they follow the monistic approach. And so once they've signed the agreement, they know that that agreement will become law in their own country, or instead countries say are much more sort of careful and don't want to create a sort of rights and obligations for their citizens. They don't want these agreements enforced in their territory, and therefore say, well, I will sign this agreement, but this agreement remains outside. So this is why we're interested in comparing these two dualistic and monistic approaches. Now, just let me go back a moment, because when we're talking of international agreements, which have always existed, we always find international agreements. Peace agreements sometimes, or agreements by which a country was somehow became tributary to another country, or alliances, defensive alliances. Well, let's move much more to our times. And here we find, in international law, we find a principle which is mostly related to a historical event, and which is the Westphalia Peace of 1648. It's really sort of rather complex history, but we generally call it the sort of Peace of Westphalia, 1648, which puts an end to a war, a 30-year war of succession, which made Europe bloody, and sort of thousands of people killed in the 17th century. Now, what is the basic principle of the Westphalia, the Peace of Westphalia, and which was developed subsequently by international lawyers? Let's see if I've made so what is the sort of the principle which we find, basic principles in the Peace of Westphalia? First is the notion of sovereignty, and therefore that the state has sovereignty over its territory. And so it is only the state decides what must happen in that territory. Nobody, so the obligation for other countries not to interfere with what happens in that country. And this is the problem, a very delicate issue of problems of interference with what happens in the country. And secondly, obviously, obvious consequence is that the borders of a country cannot be touched. They cannot be sort of non-aggression towards other countries. Now, these are sort of legal principles that have been over the last, as you see, 4 centuries have been violated many, many times, but we still have this idea that the notion of state sovereignty is based in the Western legal systems in the Westphalia Peace. Now, what is the relationship with international law? Each time a state enters an international agreement, it gives up a little bit of its sovereignty. Just think of, let's put it on a very simple metaphor. Think of an individual. An individual has autonomy and can decide to do whatever he or she wants. So that is autonomy, legal autonomy, and can decide whether wants to enter some kind of relation with other people, wants to have a contract, wants to buy a house, and so on. As soon as you exercise your autonomy, especially if you exercise your autonomy, your private law contractual autonomy, obviously what happens is that you somehow limit your autonomy. If you decide you want to buy something, well, obviously you're going to get something, but you also have an obligation to pay something. So money comes out of your pockets, so you must pay. So autonomy is very nice, but it always engages someone towards someone else. Now, transfer this in the international arena. When there's an international treaty, clearly states enter an agreement which they find convenient, but they're somehow giving up part of their sovereignty. So it means renouncing a little bit to a little piece of their sovereignty, because they're establishing certain rules, which first of all are rules that are established outside and not inside, in a different forum. Just think of an international, in a monistic system. 2 countries agree on a certain treaty, and that treaty is enforceable in the national, in front of domestic jurisdiction. They have changed, each of these countries has changed their legal system. And so you see that this has, in this case, sovereignty has somehow, they have exercised their sovereignty, but have reduced their sovereignty because that state has become engaged towards another country. So the state can no longer, Parliament can no longer do a law if it is against international treaty, because someone will say, sorry very much, you cannot do this law because it violates an international treaty. So, or the state decides that it will break that international treaty, will set it aside and say, I will renounce this international treaty, I'm no longer bound by this international treaty, with all the consequences that come out. Or the Parliament, which we suppose having the maximum powers in lawmaking, cannot take that decision because it is against an international treaty which is being signed by the state. So you see that in this case, the sort of sovereignty is, in a democratic system, obviously we're talking only of democratic systems, well, is significantly limited by the fact that the state has entered into an international agreement. So just to point out that this is why we are interested. You see that also this has, even if you follow a dualistic approach and say, well, it does not, the international agreement does not create rights and obligations which are enforceable within our domestic courts. At any rate, it's Parliament. Parliament is limited because all Parliament says, I don't care anything about this international treaty. I just throw it away. Just think, we've done Italy does an international treaty with South Africa concerning the trade of elephant ivory tusks. and at a certain point we decide, because we have a very strong ivory industry and we want to develop this ivory industry, well, that we're going to do a law that somehow favors sort of the small enterprises that do work in ivory. And well, this means if we do this, we are breaking an international treaty. We can decide we want to enter an international quarrel with South Africa. I mean, we can do it, but we know that there are also certain consequences. And the consequences would be that South Africa brings Italy in front of an international court saying, listen, you agreed that there was this international treaty, you signed this international treaty, now you've violated this international treaty, and since you violated that international treaty, dozens, hundreds of elephants have been killed by poachers in our South African national parks, and these elephant tusks are shipped to Italy for your industry. So you understand that this is just to show you that even in a dualistic approach, the fact that there is an international agreement limits the lawmaking power of a democratic institution. Obviously, for a dictatorship, you can do more or less whatever you want. You just tear the international treaty and say, I'm not bound by this, and you don't care about consequences. But in a democratic system, obviously, whatever representative institution, whether it is parliament or government, will say, well, we have signed an international treaty, and well, we don't think it is this piece of legislation. We feel that this piece of legislation is against this international treaty, and therefore, although Parliament is sovereign, well, should not pass this piece of legislation. So just to point out that this is why we're so interested in international law, because it limits the powers of. So this is what I try to express. Yeah, whatever approach, whether monistic or dualistic, international law influences structure and content of domestic systems. So, I mean, if there's an international treaty, well, you could do something completely against that international treaty, but then you know that there will be international law consequences. Now, let's try and see, because, I mean, when we talk about international law, I've tried to give you sort of very big label that tries to cover lots of aspects. But then we have to look at what is the content of these international agreements. For example, we find international agreements that are, well, that govern legal relations that are well beyond the borders of the country. Just think of, which are not therefore subject to state sovereignty, and therefore to the Westphalia principle. Think of freedom of the high seas. There was this great, I've already mentioned him as one of the greatest jurists of a modern Grotius, born at the end of the 16th century, died in the 17th century, one of genius, a real genius, Dutch, Hugo de Groot, genius, one really a founding father of modern European law. And among various ideas he came out was the idea that freedom of the seas. Obviously, that was very practical. I mean, he was Dutch, and and the Netherlands at those times, but also now, well, were mostly submerged by the seawater, and so their activity was not on the ground, but was trading with their ships in the oceans. And what they wanted to avoid is that someone's claim, typically the British or the Spanish or the French, saying, "Oh, but the ocean is mine, and therefore you can, if you enter the ocean, you are subject to my sovereignty." This was a theory of, of these very strong monarchies. Well, the idea of the Grotius was saying, no, the high seas are free. Anybody can go there without asking permission. It doesn't belong, it belongs to everyone. And everybody should go there. There are some rules, but the first rule is freedom of the seas, which clearly is functional to the development of Dutch trade. But apart from that, it makes very much sense. Just think of at a certain point, you know, in the 16th, 17th century, after the discovery of the Americas, these main powers that were looking on the Atlantic, that is Spain, Spanish Empire, the French Kingdom, and the English Crown, started saying, oh, but the Atlantic Ocean is mine. No, it's mine. No, it's... So obviously, freedom of the seas, well, everybody agrees on freedom of the seas. But this is outside the jurisdiction of the country. So do an international treaty on what happens in the seas and what you can do, what you cannot do in the seas, which is an what we call international waters. Well, just think of outer space. You have to send a satellite for telecommunications in space. Well, it is well beyond state sovereignty, but obviously you must somehow take into account that there are certain interests. You must not collide with other satellites that are already there. You must be very careful that the satellite is sure and doesn't sort of suddenly fall down and falls in a town and kills people and so on. So just to point out that there are areas which are beyond the sort of sovereign, state sovereign. So this is a kind of international treaty which we are interested in, because they tend to expand somehow rules in areas which otherwise would not be covered by rules. Or there's significant activity, especially after the Second World War, what we could call legal activism, in the sense that we find that states tend to pick up any occasion to create international agreements to cover aspects outside their borders. Just think of human rights in other countries. So therefore, you set an international rights agreement treaty, and you say, well, it's not only me that is respecting, you too must respect it. So somehow you are telling other countries that they should respect human rights. So you're trying to enter the sphere of these other countries. Typically, you do a trade agreement with a certain country and say, well, I will do this trade agreement with you, provided you introduce certain rights. For example, non-discrimination in the workplace, no child labor. So just to point out that this is very common. Sort of, you say, I will trade with you, but only if you in your country, you respect these rights that are rights which are respected in my country. Or here, just to make, I've already made this example, endangered species, climate change. Let's think of the issue of climate change, the so-called Kyoto agreement, Kyoto, the town in Japan where this agreement was signed, and somehow to reduce the emissions of CO2 and other polluting substances in the atmosphere. And that is, so we are trying to protect the whole atmosphere, not the sky over Italy or over Japan or over the US, the sky of the universe, of the world, not the universe, of the world. So we are sort of the Earth. So we are sort of somehow entering in a very complex aspect, or environmental protection. Let's think of against, pollution of the seas or of rivers that pass through many countries. Just think of the Danube that starts in Switzerland and then passes in Germany, then Austria, and then a whole lot of other countries, or a whole lot of countries before ending up in the Black Sea. So just to point out that and we want to be ensured that there's environmental protection of the species that live in the Danube. So just to point out that when we look at what the influence of international treaties on the legal system? Well, let's look at the content, and then we try to understand to what extent this content of the international treaty is already enforceable in the legal system or influences indirectly the legal system. So, first point is that we must remember that international treaties, which are a contract between nations. So obviously in any contract, you can't have everything. You somehow find some kind of compromise. You say, well, if you give me this, I will give you that. So there's always an exchange, obviously in the interest of the nations, best interest of the nations that signed this agreement, but it's never 100% in favor of one country and 0% in favor of other countries. So it's always compromise. And a compromise also in legal solutions. This is very important because lawyers are very quarrelsome and therefore they can find many ways to represent a certain situation, trying to bring to draw the blanket to cover themselves, their side, and sort of leave the other party's feet cold. But so it's always, international treaties necessarily are a middle of the way solution. And so this is interesting because this means creating a common ground. So this means that when there is a treaty, there's an international treaty, this means that you have found some kind of common ground. And if two countries, which apparently should be very, very distant from each other, let's imagine a treaty between the US and Russia, well, they find an agreement, well, clearly it is somehow they have found some kind of common ground in which they both agrees. And so what we are interested in seeing, what are the areas where there are no international treaties? Now, if we start looking at the amount of international treaties, they're immense. We would never end. We saw thousands of international bilateral and multilateral international treaties. So what is interesting to see, what are the areas where countries have already found some common ground and have found common solutions to a certain problem, and where instead the countries have not found any solution, or because it has no international interest, there's no interest in this international aspect, or because, well, each country feels that this is very much belongs to its tradition. So when we look at this, then we start looking at the differences, and these differences are not only in the text of how, on what is the law in the books, what is the black letters on a piece of paper, but we're trying to understand to what extent parties comply, states or citizens or entities of that state comply with those rules, what are the remedies, what are the procedures. So this shows us that when we look at international law, we start from a very high level and then we fall down and we start looking at how it works. So just to give you a brief presentation of these first aspects. There are many more, obviously, but I just wanted to introduce the notion of international law and why it is so important in defining what a legal system is. Are there any questions? No questions? Sorry, I'm just sort of Okay. No, just to know, every now and then, I sometimes have the doubt that sort of, I'm in doubt that sort of I've managed to transfer the notions. Now, just let me do an example. If you that last slide of the notion of sort of where countries find a sort of common ground, find common rules, and then what we have to do is look at the compliance and remedies and procedures. Now, let's take it. One, rather, nobody sort of cares very much of this international treaty, or rather, two international treaties signed in Vienna at the end of the 60s, and that these treaties concern road circulation. I said, what are we interested in that? Well, we are interested in this because these treaties are those which establish not only uniformity around the world of road signals, stop, no parking, no U-turn, but basic central pillar of this is traffic lights. Now, you go to sort of various countries, you travel around the world, and you find that that the traffic lights are generally disposed in sort of red is up, yellow is center, green is below. More or less the same, nearly always, not always, but mostly like that. So there's this international agreement which establishes exactly the color, because it doesn't say it says amber, it doesn't say yellow, it says amber. We generally say, well, it's a yellow light, but it's instead it's amber. So this is what the international treaty says. Now the problem is, once we have an international agreement which sets how, and the fact that the sort of the so traffic lights must be round. They can't be of a different shape. They are round. Color, the green, the red, and the yellow light are round. You can't do them sort of pentagon or some other shape, because the international treaty tells you how they. So once you find that all around the world traffic lights are the same, does this mean that traffic works in the same way whether you are in Stockholm or in Naples, whether you are in Denver, Colorado, or in Calcutta in Bangladesh? Well, obviously not. I mean, you don't have to easily understand that, that these, they may be common rules, but these common rules do not necessarily shape social behavior in the same way. I just make this example of traffic lights because it's a very good example of how you can have exactly the same rules, and take problem of parking. So you can't park. Now, anybody who lives in Rome, and I think also our foreign students who have been in Rome sometime, know that, well, it is forbidden to park, especially you should not park in a double line, especially when there's a policeman there. But I mean, generally speaking, in Rome, but not only in Rome, we find other parts of Italy and other parts of the world where, well, generally speaking, you don't park in a second line, but occasionally you may do that, and sort of it's not considered to something that you can't do. If you try doing that in Oslo, obviously, you will be brought to court immediately. So just to point out that this shows that, you can have the same exact rules, and then what we're interested in, and it's an international law, it isn't that suddenly sort of the 150 countries in the world decided, they said, oh, but that's a very good idea of having traffic lights. No, they have joined these two international conventions, and they have signed them, and they have established how traffic lights must be, and traffic lights are more or less the same all around the world. But the fact that they follow the same rules does not mean it doesn't mean that the traffic is the works in the same way. Now, Shabadi asked, can you explain the last point of the last point of the last slide? Well, this is exactly what I'm trying to point out. Obviously, we're very much interested in international law because international law is a very important. I would focus on this in international relations. In a global world, we cannot do without international relations. But we mustn't think that once there's an international agreement, everything is fine and everything is going to work out for the best. It often happens that there's an international agreement and then, well, parties do not follow that international agreement very much, and they're sort of somehow rather all these trade agreements between the US and China, and then US says, oh, but you violated our this international treaty, you're doing some things, you're dumping products produced in China, you send them under the cost in the US to destroy our economy. So just to point out that it is, we should look, as lawyers, we have to look at what is written in an international treaty, but then when we see how this international treaty is actually works, well, we have to look again at the compliance. What is the compliance rate? What are the remedies in case of violation within the domestic order? And what are the procedures which are followed if someone does not comply with these international principles that have become part of the domestic system. So I hope this is this makes this answers Shabadi's question. Now, just let's go back just to open, and I'll go on this. So what was important is when we look at the indirect role of international treaties, this we mustn't forget, it's very important, obviously, again, Western legal systems, legal tradition, democratic systems, which we follow the rule of, let's call it rule of law, or whatever we call it, Stato di diritto, Stato di droit, whatever we call it. So we're talking of these. So international law has a very profound influence on values, principles, notions, and partitions. So when we find something in an international treaty, whether the country is a monistic country or a dualistic country, whether that international treaty is only binding for the state or it is has immediate effects within the domestic jurisdiction, what is contained in the international treaty has very important effects on how the law will regulate that aspect in the domestic jurisdiction. Let's imagine that there is an international treaty that is signed by a country which follows the dualistic approach. Does this mean that the country can disregard it? No, we know we cannot disregard it because it will incur in international liability. This is what happened quite regularly with the UK when the UK said the European Convention of Human Rights, we've signed it, but does not bind our courts. It's not enforceable in front of our courts. Obviously, we will respect human rights, but we decide what we feel is the way human rights should be followed. So this is a very long story that went on for 40 years and then was finally solved by the Human Rights Act. But we see that there are values. So what happens when you have to introduce, if you are a dualistic country and that international treaty does not have effect in your domestic jurisdiction, but you want to introduce in your own domestic jurisdiction a piece of legislation, you can't say something, well, something completely different, something that is completely far away and from what the international treaty. Those values, if the country has signed those values, well, those principles, well, it is, you can't just do with your right hand, you sign the treaty, and with your left hand in parliament, you do something completely different. Of course, you can, but you sort of, this is very bad for the reputation of the country, and obviously this means in democratic systems, citizens will complain and say, listen, how is it that you signed this international treaty and then you have voted for a law, or you are applying a law that is contrary to this international treaty? So it is, in a democratic system, this is negative for the public opinion, who have a very poor view of government and parliament. So, and further element, well, these international treaties are used as a persuasive argument. You say, well, listen, this is the argument that why we feel that this argument, this solution is the best solution. Why? Because it has been applied in an international agreement, has been voted by these very respectable countries which enforce it. There's nothing happened to the sovereignty of these countries by enforcing this international treaty. So you see that it is when the national parliament has to somehow introduce some piece of legislation, well, international agreements have an important effect on the lawmaking process. So just to show that whatever the approach, I tell you, monistic or dualistic, well, we're very interested to see what extent international law influences the way how legal systems are shaped, and they're shaped, and somehow often they are shaped in a common way. They are made. Sort of legal systems tend to be similar because they follow principles, values which are set in an external treaty, but the members, the countries which have signed that treaty say, well, we too should follow these principles within our domestic jurisdiction. So this is very important because it shows what the difference is. And then there's a further element, and this is what I want to point out, that international law is one of the most common instruments of global governance. We have a global world. No country, whatever some people think, sort of some leaders think, no country can do by itself. Then there's a pandemic, and you find, yeah, well, you can blame someone, but anyhow, you find a solution which is a worldwide solution. Putting the blame on someone will not somehow solve your problem. So we find that increasingly, whether it is international economic system, whether it is climate change, whether it is health issues like the pandemic, well, countries need to cooperate and find common solutions. And even if you're a very big country, well, you still need cooperation by other countries. I mean, obviously, if you're a small country, Luxembourg, Malta, well, it needs cooperation, lots of cooperation by countries which are nearby. But even if you're a very big country, you need somehow find cooperation. So the point is that international law is very much influenced by series of international governments. So we will be had here very much in radio, TV, on the internet, this issue of multilateralism or isolationism or bilateralism. Well, obviously isolationism when a country thinks that it can do everything by itself, but North Korea cannot do everything by itself and somehow has to have a very strong agreement with the People's Republic of China. So already this brings from a total isolationism to a bilateralism. So, well, I'm not going to have anything with South Korea and with my enemies, which are all around the world, but I will have relations with bilateral relations with the People's Republic of China. or you have multilateralism, in which is a sort of political, international political theory, which has been very much developed after World War II through the United Nations, in which solution of the world problems are through multilateral agreements. Now, obviously, you will hear, when you read not political speeches, but specialists in this field, you find that the opinions are very diverse and some feel that multilateralism is no good because it doesn't bring any way. At the end of the day, it's always sort of you go at very low compromise and doesn't bring results. Others feel that, well, you could have multilateralism, regional multilateralism, only between certain countries, and so on. But it has, just to point out, that international law is an instrument to put into place these international political theories. So just to point out that, again, we cannot just think that this is just a legal aspect. It is clearly the law. We are interested in law, but we are also interested in understanding how it somehow, the law is adapted to what are the dominant in a certain moment of history, international political theories. So for today, I will stop here, but if there are there any questions on today's lesson? Any more questions? No? Please, if you can please just put your name, because I wasn't able to write down all the names of those who were present, who were attending the classroom. So if you just sign, just okay. If there's no more questions, well, we reconvene tomorrow Tuesday at 4 p.m.